So what we're going to go through, first of all, is just the basics of ad valorem taxation. Again, it's not as intuitive as you would expect. I'm going to talk a lot about residential valuation and also a little bit about oil and gas valuation, mostly just to show the difference and sort of point you in the right direction. It's a lot more involved and complicated. It would be a presentation all on its own. So this is the response I generally get when I call from a client that says, you're not going to believe what they say my home is worth or what they say my unit is worth. So I like the idea of an assistant with defibrillator in hand. The problem is just arguing that the number's too high is not enough. So what you have to do is discover or create a combination of a legal standard. What is it too high relative to? And then the facts demonstrating a violation of that legal standard, just like you would in any other case. So legal standards are found in code provisions in the Constitution. We'll talk about a couple of those, case law, and then the comptroller has instructions out on his website that, particularly if you get into the oil and gas arena, are very helpful. So you got to understand the parameters to evaluate the appraisal. You've got to protect your right to protest. All of this, the concepts and the data and the arguments that you have are worthless if you do not protest correctly and protest in a timely manner. There are statutory tools that allow you to collect data. You can use those. You've got to protect the record. Just like any other case, you don't want to share information or show your hand until you know as much as you can know from them. My dad used to say, you learn more with your mouth closed than your mouth open, and that is my mantra when I'm talking to these folks. So you're going to arm yourself to negotiate a reduction in value or prevail in court. Most of the time, if you can go into this demonstrating that you know what you're talking about and you know what you're looking at, you will reduce your value. So sort of the cornerstone of appraisal is market value. And the code provision says it's chapter 23 of the Texas Property Code. If you want to look it up and see what else is in there, we're going to talk about other parts of 23 as well. All properties appraised at its market value as of January 1st. A couple of key things there. Market value is, I spelled it out here, but it's our typical willing seller, willing buyer definition. The way I tell my clients is, if you were going to put your house on the market, these are the things that you would think, this is the price you would arrive at after you talk to a realtor and compare your properties to neighboring properties, properties that have sold, properties that haven't sold, to arrive at the value that you would expect to get for your home. Key up here is January 1st. Now, I'm in West Texas. So this year, since January 1st, we've been hit with negative oil prices and this virus. None of that matters this year. If it didn't affect the value as of January 1st, it doesn't count. And so arguing about those two things will get you nowhere. So in contrast to market value, which is just the willing buyer, willing seller, we have something called appraised value. And that's whatever the code permits you to be taxed at. So appraised value, you also see it called assessed value or taxable value, can mean market value as limited by a provision of the code. For example, there's a homestead cap that controls how quickly the value on your residence can increase. It could be a special appraisal provision, a formula that derives a value, an appraised value, versus the market willing buyer, willing seller measure. Generally, when you're talking about an assessed value, it's a formula. Oil and gas interests are an example. And this is key. When you argue with an appraisal district, they're going to tell you that everything is market value. And the reason is because it's amorphous and it's easier for them to defend. So any chance you have to come back and say, look, the appraised value in this case is not the market value. It's a capped value. It's a constructed value with these variables. Those are good angles to get a hold of something to really argue about. So this is an example of a residential value statement. Every county, they do them a little bit differently, partly because this is quite a racket in Texas, in my humble opinion. There are 3 law firms, sometimes a 4th, and 3 appraisal firms, sometimes a 4th, that compete for contracts, appraisal contracts with these counties. And so depending on what appraisal firm you're dealing with in that particular county, the backup information behind the number that they send you is going to look a little bit different. At bottom though, it's the same. And so we'll break this one down. I'll show you in a minute an example of one constructed a little bit differently that contains the same information. And then any one you look at, you'll be able to pull these pieces out of. Okay, so first, again, on your house, there are 2 measures. There's an improvements number and a land number. And if you look over to the right, you can see in decreasing order the last 4 or 5 years for each of those value baskets or categories. Key here is that in this particular instance, the land value hasn't changed, but the improvement value has. And that is my first clue that what I'm going to want to attack is the improvement value. I'm going to want to show the appraiser that nothing has changed last year that would increase that value. Other key numbers on here, the improvement value plus the land value equals the market value. And then we talked about this a little bit earlier, assessed value is not necessarily the same as market value. And so you can see the numbers down at the bottom. The assessed value is the value subject to tax in this year. So another thing that will happen is you'll call the appraisal district. Excuse me 1 second. You're gonna have to wait. Okay, go. Go on back. I'm sorry, I've got kids and dogs, so we find ourselves these days. So the assessed value is what's subject to tax this year. So, I have a client call and say, I called the appraisal district and I said, $354,000 is ridiculous. My house is not worth that. And they say, relax. It doesn't matter what the market value is. You're only taxed on the assessed value. So this is the number that you need to be worried about. That is true in this year. It is not true going forward. And I'm going to show you how that works. So don't let your clients get too focused on the taxable value this year. It's the market value that you need to be aware of. And you can see over time for this taxpayer how quickly that market value number grew. We challenged it back here. And so that's why we got it down to 286. But, in a little over 4 years, you're looking at almost $100,000 difference. So you'll hear the term homestead cap or market value cap. And this is what makes the difference between market value and assessed value or appraised value. It's the limitation on how quickly your appraised value can increase in a single year on a home. So it's going to be the lesser of the previous year's market value. I'm sorry, that should say current year's market value. It's the lesser of the current year's market value or the previous year's appraised value plus 10%. And then if you've made any improvements, they can tag that on there as well. As we've seen, the tax statement shows both. A good way to think about that assessed value is it is as much of the market value as the code permits you to be taxed on this year. The market value acts as a cap on that assessed value though, and that is why it is so important. And we're going to talk a lot about the frog in boiling water theory. Okay, so how does this work? Let's say you're this taxpayer, you've been handed a statement that says your market value this year is $354,700, your assessed value is $335,600. You can see the difference right here. That homestead cap, the number 19, is just the difference between the two. This year, to reduce your tax, you're going to have to argue that the market value is less than the appraised value. So when you approach this, you're looking at how much difference am I going to have to make in order to make a difference this year. And it's that homestead cap represents that number. So I'm going to show you an example. Let's say you argue that 354 is ridiculous. Your market value number should be 300,000. Well, what happens then is that your assessed value also drops to 300,000. We have two constitutional provisions in Texas that control. One says you can never be taxed at a number higher than your market value. Drop your market value, you've dropped your taxable value. The second concerns equality, and we'll talk about that in a minute. Let's say you can't do that. Let's say you can't get that number down that low. You need to argue it anyway, because whether or not you can get far enough, your market value far enough down to make a difference this year, if you can keep your market value low, it keeps your assessed value in future years low. As you can see, there is no cap on the increases in market value. Just to give you an idea, I live in a town of 800 people in West Texas that most people would consider the armpit of the earth. My house value went up $98,000 this year on about a $220,000 house, maybe. So anyway, you need to keep that in mind. So here's an example. Let's say back here in 2013 or 2014, this taxpayer had argued that the market value at 338 was crazy. It really should be 290. And let's say the appraisal district agreed with that. Well, in 2014, it wouldn't make any difference because the assessed value is still less than that reduced market value. But look what happens going forward. If you can maintain that market value number, your assessed value can't exceed your market value. So all of a sudden, you've dropped your assessed value this year as well. Now going forward, this 335 isn't going to fly unless the appraisal district can justify increasing 290 to 335, and 335 is not more than 10% more than the previous year's value. Anyway, so it's important. This is the frog in boiling water theory that I mentioned. If you don't get a hold of it early on and stay on top of it, you turn around one day and your market value is so much higher than your assessed value that you cannot in a year reduce it to reduce your taxes. So what do? You challenge the market value every time it increases appreciably. Use it as a cap. How do you successfully challenge it? One very obvious, but frankly very overlooked avenue are mistakes. When I got in and looked at the backup information behind my number this year, they've all of a sudden added about 500 square feet to my house. I don't know why. I don't know where it came from. We haven't added on. We haven't done anything. That is just a mistake. But that's an easy argument to make, to go to the appraisal district and say, look, you've taken my 2,400 square foot house to 2,900 square feet, appraised it accordingly. You need to take that off, and that comes off the top. So that's a pretty easy argument to make. Another avenue are the comparables that the appraisal district uses. These guys use a mass appraisal computer program. And so for each property, they're going to have selected, or the computer will have selected, 3 or 4 homes, pieces of land, depending on the interest at issue, and adjusted them appropriately. The computer has done that. And most of the folks that you talk to can't tell you exactly what the computer did. They just know that's what the computer said. And they'll use those to support the value they've placed on your property. So how do you get a hold of this information? Because they did not volunteer it. There is a tax code provision, and I've laid it out a little bit later in this presentation, that authorizes you to request the data, the statutes, formulas, anything they use to support their value, requires them to get it to you, and requires them to give it to you 14 days before the hearing at no charge by first-class mail if you request it. If they do not do that, they can't use that information either. So as a practical matter, what happens is if you don't get this packet in a timely manner, when you show up and say, hey, you can't use that information, they table the hearing and they reset it for 14 days later, so you get your 14 days. So what I generally do is if I get within that time frame and I haven't received what I've asked for, I call and say, hey, you still haven't sent me this, and let's reset the hearing, and that's what they do. You can look at neighboring properties, and I'm going to show you again in a minute how to do that as well. Exemptions. For whatever reason, out here this year, we've had a bunch of people have their ag exemptions yanked. I'm not sure why. I'm still trying to investigate, but you can look on each county's website. There'll be a link to exemptions, and it will show the exemptions that are applicable in that county and generally what you have to qualify for one. So, I mean, the over 65 is pretty obvious, but there are veterans exemptions, exemptions for people with disabilities. They're different across the county, so you want to check and see what applies in the county that you're in. So the first thing I'm going to do is check my online tax statement. So I've got in here HCAD, Howard County is where I am. What you're going to do is go to the county website. Word of warning, there are all kinds of fake phishing. I'm not sure what the right term is. Websites out there that look like the right one. If anybody tries to charge you for anything, or just make sure you're on the official website, and it will be obvious when you are. You're going to choose the property search icon, search by your name. In larger counties, or if you have a common last name, try the advanced search with your house number, and that generally gets you closer. You're going to scroll through and check for accuracy. I'm going to do this in just a second to show you how it works. Compare it to the previous year, compare it to the neighborhood. So let's do this real quick. Okay, so this is the Howard County website. I'm going to go to property search. You note down here, this is tax year 2020 I'm looking at. And this is all public information. And you can find this on any property pretty much anywhere in the state of Texas. So a few things I'm going to check. First, I'm going to look at the legal description. The property I live on was divided into blocks or into lots, and we sold a lot a couple of years ago. So last year I had to go in and correct this so it said lot 1 through 9 instead of 1 through 12 or whatever it was. They had dinged me for those additional lots that had been sold, even though they had taxed the new owners as well. So that's one mistake to check for. Over here, you can see the values that were on the sample tax statement, the home site value. This is I'm not sure what they've got. This all should be homestead on here. So that's another thing I need to talk to them about. Here's my land value. And you can see that the sum of those numbers is this market value. So that's the number that I'm looking at to cap the actual value of my property. And then down here is the assessed value. Here's my homestead cap loss. So I know when I challenge this number to change the value I pay on this year, I've got to make at least this much difference. And that's going to guide how I set up my arguments. You go on down, it will show you the taxing jurisdictions. Every now and then these are incorrect. You know, where we live, there are a couple of ISDs that are very close. You want to make sure that the property you're in is in the right school district. If there's a water district that you really are a part of it, I mean, this is a mass produced set of data, and so the opportunity for mistakes is pretty high. So here, this is what I mentioned. Last year, this number said 2410. This year, it says 2810. First thing I'm going to ask the appraisal district is, where'd you get 400 extra square feet? Because there aren't any. Another thing to look at are the pieces, the components. For example, a covered porch. Do we have a covered porch? Yes, we do. Do we have a storage building? We do. We don't have two. I'm not sure where the second one came from. And I have no idea where they got a detached garage. We don't have a detached garage, have never had a detached garage. I don't know where it came from. So what happens is they put the number of square feet in each of these categories. The categories are valued differently. Then they add all that up to get your value up here. So look to see that the components in here are correct. For example, yours might say you have a pool and you don't. One landowner last year, and this seems to be real prevalent in rural areas, the taxing groups will use Google Earth pictures. And so they had tagged this particular structure as a heated horse barn. Problem is, it was a dog kennel. It didn't even have solid walls. And so once I talked to the lady and said, you know, this is not a horse barn, this is a dog kennel, well, it fell into a different category that was valued at a much lower rate, which reduced the value. So you can pull these component pieces apart to argue market value. And here's my history. Like the one that we looked at earlier, this one's backwards. Instead of the years being across the top, they're on the side. But you can see how the values in land have changed and how the values and improvements have changed. One sort of common situation. Let's say you're looking at your statement and your market value is $200,000, and last year it was $200,000 too, and the year before that it was $200,000. And you realize when you look at the statement that you should have probably argued about that 2 years ago. So you're going to call the district, they're going to say, hey, you didn't argue about it last year either, it didn't increase over last year, you know, we're not going to do anything for you. But you look back the 2 years before that, and maybe in year 5 or year 6 ago, it was at 100,000. So you don't have to go in and argue that, well, it didn't increase over last year, but it's too high. You can say, look, in the last 5 years, it's doubled in value. Something's not right here. And so sometimes taking a longer look instead of just looking over the previous year helps you a lot. Okay, speaking of the previous year, the other information, well, two things. Let me talk about this map first. So the blue outline is the property that we're looking at. The lots over here are vacant. My neighbor over here has vacant lots also. I'm probably going to go look at the backup information when I just pulled on my own property on these neighboring properties and make sure that they're valued the same or close. The way I do that is go back to the property search page. If you'll notice this number right here, 11900, is the last 5 digits of the property ID. When you go back, you've got to pull the whole property ID string in order to get anywhere, but the websites are not user friendly, but you can figure it out. So one thing you want to do is go back and look at the neighboring properties as well. Another thing, particularly if you're arguing year over year, look at last year's statement, see what the differences are. And as I mentioned last year, actually it was 23, not 24. That 2310 went to 2810. That's a big jump. That's what is responsible for the jump in value on my statement. So that's where I'm going to start. Okay, enough of that. Let's go back to the presentation. So again, definitely pull that backup data and make sure that they've got your property represented correctly. Okay, so let's talk about collecting data. The property tax code has section 41461. And it says at least 14 days before the hearing on a protest, the chief appraiser shall inform the property owner that the owner or agent can inspect and may obtain a copy of the data, schedules, formulas, and all other information the chief appraiser plans to introduce at the hearing to establish any matter issue. When I file my protest form, I send a cover letter that says, I hereby request a copy of the data, schedules, formulas, and all other information, and just quote the statute. And then I know I have asked for everything I'm entitled to. They know I've asked for everything I'm entitled to. Lots of times a letter like that will prompt a phone call and an offer to settle. If you know what you're doing, you're not worth their time lots of times. New this year, this was effective January 2020. They cannot charge you for copies. Also, they have to deliver them by first-class mail in an electronic format or by a secure website. In the small counties out here, we've still got appraisal districts insisting that people come get their information. If they don't come pick it up, it's their problem. Well, that's obviously even more difficult now with all of the restrictions and advisories to stay at home. So this is very significant in the smaller counties. I suspect the larger counties are already doing that. And again, now if you request it by first-class mail, they have to send it to you. So 41461 is the formal request for data. I like to ask informally also, but again, if you're going to pick up the phone and call an appraiser, go back to my dad's rule, you learn more with your mouth closed than your mouth opened. Ask questions, don't answer them. If they push you for a value, it's fair to say, look, I think what you've done is too high, but I need to see what it is you've done. I mean, maybe I'm missing something, maybe I don't know. Learn as much as you can before you take a position. Okay, back at the beginning, I showed you the first part of section 2301, which says that all properties appraised at its market value as of January 1st, ... Here's the rest of the ... except as otherwise provided herein. And herein, of course, is chapter 23 of the tax code. The bulk of chapter 23 contains what are called special appraisal provisions. So the value of an oil and gas interest, how to value inventory, mobile homes, ag interests. There are a couple of dozen provisions and they change frequently, pretty much every legislative session. So these are interests where market value, willing buyer, willing seller, is not the standard. I'm going to use oil and gas interests as an example because where we are, we do a ton of oil and gas. And so I have the opportunity to argue about oil and gas interests more than anything else. The oil and gas provision is section 23.175. It's not a market value measure. That is section 23.175. It's a long way from willing buyer, willing seller. What it does, though, and I'm not going to read through this obviously, is it highlights different variables: future income, average price, a price adjustment factor, an escalation factor, the price in succeeding years, the methods to discount future income to arrive at a discount rate. And it mandates that the appraisal district use the appraisal manuals developed by the comptroller, which can be pulled off the comptroller's website. I'm not going to step through this other than to just point out that if you're attacking a special appraisal, rather than looking at what affects the market value, you're going to have to look at these individual variables that plug into the formula that yield this appraised as opposed to market value. Okay, I said earlier there were two constitutional provisions in Texas that impact ad valorem tax appraisal. First one is market value. You cannot be taxed at a value that exceeds market value. The second, though, is just as significant, and it's equality. 42, I think it's 26 of the code, allows you to challenge not only the market value of your property, but whether your value is arrived at in a manner equal and uniform with other taxpayers. So I'm going to jump down and look at the provision, and then we'll go up and talk about how it's reflected in the statute. So the provision says taxation shall be equal and uniform. So you've got, again, two provisions. One says you can exceed market value. One says it has to be equal. Well, spinning that out, a value that is unequal but less than market value is permissible. A value that is less than market value but unequal is impermissible. So it's not enough to say, if you're the appraisal district, that, okay, you're not taxed at above your market value. They're both necessary. it has to be equal, and it has to be less than market value. The case law suggests equality trumps market value for that reason. Okay, so you've looked at your data and you don't like the numbers and you're going to protest. What do you do? Most of the appraisal districts send a form with your notice. If they don't, you can pull it off the comptroller's site. It's real easy to find. You don't have to use it. What I have found is, again, this is a bureaucracy and it's a large one. If you send them something that doesn't look like what they've seen before, it raises more flags and causes more trouble than it's worth. I just use the form. I fill it out on my terms, though. The purpose is to indicate the grounds on which you're protesting, market or appraised value, inequality, any other. There are usually about, I'd say about 20 different categories that you can, on which you can object. Paint with a very broad brush, and here's why. Until you file your protest, you can't ask for the data. Until you get the data, you don't know exactly what these guys have done. And so what you don't want to do is be caught in a situation where you discover later that the ground of protest you'd like to pursue is one you did not select. So I generally walk into an ARB hearing and they say, you objected on 6 categories. And I go, yeah, the only one I'm interested in today is market value, or the only one I'm interested in today is inequality. And that's fine. It does not work in reverse. If you've said you're challenging market value, you cannot then go in and challenge inequality. Other basis for protest, here are some examples. They'll all be on your form. Notice. This is one of those situations that gives rise to clients outsmarting themselves, and it goes something like this. You know, I get a phone call and it says, you know, I tried to protest and they told me I was past the deadline. I said, well, did you receive notice of your value? Well, I didn't receive the form, but I got on the website and I knew what my value was. So you can protest notice if you did not have actual notice. The trick is, if the value doesn't increase, they don't have to send you a notice. So the fact that you didn't get one is not automatically, shouldn't automatically tell you that there's supposed to be one. If the value stayed flat, they don't have to send you one. So what you can protest, though, is an increase where you did not get notice of any kind. You didn't know. There is a separate statutory provision for protesting the lack of notice. And so what you end up doing is going to a hearing and saying, I didn't get notice. The appraisal district or appraisal review board rules on that. If they say, yeah, you didn't get notice, then you get to argue your value. So again, you're generally going to have to pick your grounds before you get data. You waive a ground that you don't raise. So check anything that might conceivably apply. And then I include what I call my independent statement of grounds. There's a box next to it, usually says other, or anything else you want us to know, something like that. I say that the appraisal violates the tax code, the applicable statutes, the common law, the Constitution, and generally accepted appraisal principles. I have yet to stumble in a situation where I learned something from the data I get later that I can't cram into one of those categories and say I've preserved my right. I have had to use that before. The time frame is jurisdictional. You've got 30 days, generally 30 days from receipt. And the reason I say generally is sometimes if they mail them too early, you get to the end of May, even if it's more than 30 days. It's not something you want to play with. It's not something you want to push. It is jurisdictional. If you do not timely mail your protest and you can't prove that you did so, you may waive your right. Key date is a postmark date, so make sure your envelope's postmarked. You can send by certified mail. You can fax or email, just keep the receipt. More and more appraisers are just asking you to email your stuff. So as long as you can prove you sent it and it was received, you're good. You're going to collect data in two ways, informally and formally. But just as important is what you don't share. I intended to talk about this when we talked about the form. Section 3 of the form contains the boxes that you check. Section 4 will say something like, what do you believe the value is? Or what other facts can you tell us that might influence how we value your property? Something along those lines. Don't answer those questions. They're optional. It will say on the form that they're optional. You don't want to commit to anything at the time you file your protest. You want to see all the data and all the information first. Keep in mind that this is an adversarial process. The appraisal district will have a case for value. You will have a case for value. The appraisal district can choose to negotiate with you, but the ARB is the ultimate judge. So you can think about it as, if you're the defendant, sending the plaintiff all of your discovery before you've asked for any of theirs, and knowing that it's not the person you're talking to that will ultimately make the decision. So be careful what you share. The other thing to keep in mind is, particularly now, anything you share with the appraisal district lives in perpetuity. It will haunt you next year and the year after that and the year after that. And that's all laid out here. Gather everything you can, ask informal questions, don't show your hand. Okay, so let's say you've gone through the protest process, you've gotten your data, the appraisal review board has scheduled a hearing. The review board is just a panel of taxpayers in the county, and they have varying degrees of experience and sophistication. In the larger counties, they might have 40 board members, and they sit in panels generally of 3. I've had panels of 5 before. In the smaller counties, our board has 4 members, and they sit in panels of 3. So you see the same people over and over again. I've been really pleased with the Howard County board here. They are thoughtful, they'll listen to you, and they seem to try to want to do the right thing. Most of the time, the ARB is about a step above kangaroo court. There's one county in particular I hate going to. They don't listen, they don't care what you say, they're not going to look at your data, and they're not particularly nice about it either. So for better or worse, I advise my clients that when I'm going into that county, I'm probably not going to get any relief. If we're going to take it to the ARB, we need to be prepared to take it to court. And we've done that. You can appear in person through an agent or by affidavit. If it's your home, appear in person, of course, or hire an agent. Whether it's an attorney or some of the appraisal firms, most of them do a really good job. And for properties that are not of extremely high value, it just doesn't pay to hire an attorney, which is part of the reason that I'm doing this. I want to be able to share this information without somebody having to get upside down to get it. The only time I ever appear by affidavit is if I've already got one in litigation. So let's say I have a property that I filed in district court. I filed that appeal last fall. We've rolled around. We've got a new value this year. We know we're just going to roll that value, that this year into last year, into that existing lawsuit. I don't want to show up and say anything. The other side doesn't want to show up and say anything. I file my affidavit, preserve my error, we get on down the road. But that's really the only good use for an affidavit. They're generally 15-minute hearings, although again, this varies county by county. We've got an appraiser here that just talks a lot. And if you happen to get across from her in an ARB hearing, she will chew up most of the 15 minutes. I've never had the board not give me equal time. The district technically has the burden of proof. The way the code is written, if the district does not support their value, the ARB is supposed to accept your value. It never works that way. This is one of those situations where familiarity breeds credibility. And besides, the district has paid enormous amounts of money to hire the appraisal firms that then show up and argue these cases, or they're in-house appraisers. Because they're on the payroll, they tend to get the benefit of the doubt most of the time. Now, that's not to say you can't get relief, but you're going to want to argue more for why you're right than why they're wrong. Most counties will, let's say you set your hearing at 9:15. At 9:15, they're going to come get you, and they're going to pull you back in an appraiser's office, and they're going to try to settle this. They're going to try to resolve it. Generally, that's the best offer you're going to get. So you need to go in with a number in your mind, and if I get this number, it's worth settling it versus going to the ARB and taking my chances. Lots of times the ARB is a step if you know you're going to go to court. So you just have to have those numbers in your mind, and don't let that surprise you. Some counties don't do it at all. Howard County doesn't do it. I've never walked into a Howard County hearing and then pulled me aside and tried to settle it. Now, I've settled several over emails with the chief appraiser, but if it gets to the point of a hearing here, you're having a hearing. The district will mail a formal order granting or denying the protest. Most of the time, they'll vote right in front of you. They'll discuss things back and forth. They'll ask questions if they have any, and somebody will make a motion, second it, and approve the motion. The receipt of the formal order is what starts your timetables going forward. So be careful. I always tell my office, save an envelope. If anything comes from an appraisal district, save the envelope and write on there or stamp on there when it was received. You can appeal to district court. The appeal is de novo, and they will often, the districts will often use that to scare you. I could support a higher value. If you challenge this, I'm going to take you to court and you're going to pay more than I'm saying you're going to have to pay now. It makes me very angry when they do that to just regular people, but they do. Again, the timeline to file is jurisdictional. If you miss the deadline, you've waived your right to appeal. The deadline is either 45 or 60 days. And the reason I say that way is it's changed often enough and bounces back and forth between legislative sessions that I don't even want to try to commit it to memory. I go look every year. You have to pay the amount of undisputed taxes. So let's say you appeal, you file your case in district court. The deadline to pay your taxes is January 31st, on or before January 31st. You're not going to have a resolution by then, obviously. So what you've got to do is pay at least the amount that you do not dispute. So if they've claimed that the value is worth $200,000, you think it's $150,000, you figure the tax rate on $150,000, and that's what you have to pay to preserve your right to go forward. There are pros and cons as far as calculating that amount. You've pretty much set a floor if you pay on 150. If you pay on 150 and you're later wrong, you're usually responsible for penalties and interest. If you pay on 200 and you're ultimately right, they have to refund it. I generally advise clients that if you can, go ahead and pay on the full amount. For one thing, you haven't taken a position as far as what the floor should be, and then two, you don't have to worry about penalties and interest accruing in the meantime. Whether you should appeal has to be evaluated on a multi-year basis. If you've got a situation where your market value is so much higher than your appraised value that you're not ever going to get over that hump, may not pay this year, may not pay next year, but if you don't get a hold of it now, you're never going to get a hold of it. So you've got to think about it on a multi-year basis. Same thing with oil and gas interests. Even though it's not a market value number, if I can get a value this year that's lower than what was put out there, then next year I'm starting at a lower number to argue about any increase. So it does pay dividends year over year against that frog in boiling water theory. A few years ago, the legislature added an arbitration provision in lieu of litigation. If the property is either a residence, homestead, or the total value, whether it's commercial, oil and gas, whatever, is $3 million or less, you can ask to have your case submitted to an arbitrator that is a member of the comptroller's property tax panel. Now, a few years ago, I was on that panel. And so I got to do some of the arbitrations, and that was a great learning experience. You got to see where the district was coming from, where taxpayers are coming from. And as the arbiter, I learned a lot about what to present, because I spent a lot of time thinking, I understand what you're saying, but that's not what I need to know. That's not what I want to know. And so it's definitely influenced the way that I approach these cases. Over the last, 3 or 4 years, they've really upped the qualifications to be on that panel. So you generally get someone who knows what they're doing. They know the code, they understand appraisal, and they're generally qualified. They're going to be more qualified, frankly, than your average appraisal review board member. Generally, you end up with a number somewhere in the middle. So again, on either a residence or a property at less than $3 million, it may make economic sense to try arbitration versus litigation. It costs, again, either $250 or $500. It changes just about every legislative session, so you just have to look. We've talked about paying the undisputed amount. This is just kind of a summary. And practically, you want to protect your ability to protest on broad grounds. I cannot say that enough. Get all the information you can, formally, informally. Don't commit to anything too early. And hold the taxing entities to their duties under the code. I've given this presentation several times, and comments I get back sometimes are, you're really cynical about this, or you really don't trust these guys, or some variation of that. The way I look at this, you've got an individual on one side and a government bureaucracy on the other. We're talking a mass appraisal process. They don't have time or interest in looking at any individual property, and the rights they have under the code greatly exceed those of the taxpayer. So I want to arm my clients to make the best case that they can. So what obligations they do have under the code, we're going to hold them to it, to hold them to the law. Sending the data, proving their case, whatever it might be. Special appraisal provisions. Don't let them tell you that this oil and gas property is appraised at market value, because that's not the right measure. Get the data you're entitled to. Push them on their burden of proof. Again, at the end of the day, the ARB probably is not going to carry the day, but I tell them every time I walk in there, look, you've got the burden of proof. You put this number out here, you need to support it. And don't be the frog. Any gain you make in any given year will assist you in years to come. And that's all I have. Several people joined during the presentation, so I do want to say that the slides are going to be available on our firm's LinkedIn website if you want to download them. If for some reason you can't get them and want to shoot me an email, feel free to do that. And I'm going to give you my email address. It's bmanning@lwmattys.com. Zoom's going to kick us off of here in 7 minutes, but I would be happy to answer questions if you've got any.
Brandy, this is Jessica. I had a quick thing I wanted to mention, that we applied for the CLE credit, and I did get the course number. I shot it to the group in the chat, but for those who want to do self-reporting for CLE credit, it's 174086083. I'll read it one more time. It's 174086083, and that's for 1 hour of CLE credit you can self-report.
Thank you for doing that. She volunteered, saw my post and volunteered to apply for CLE credit for it, so I very much appreciate that.
Everybody could use them.
Right. The other thing I wanted to say too is, I know for people in the Texas Lawyer Group, this was really short notice. If there's enough interest, I don't mind repeating this as well. So it'd probably be Friday again, because we're going to run up against deadlines before too long. So if you've got friends or colleagues that are interested, again, if there's enough interest, I don't mind doing it again. So are there any questions?
I have a question.
Okay.
I went into my county, which is Hidalgo County's appraisal district, And when you looked at those, I guess what you want to call the homestead and all that stuff, there's like codes that are associated with that. Is there a website or somewhere where I can decipher some of those codes?
The codes that are on
The actual appraisal, so where it says patio, there's like patio, and it'll say BR12-D, and then it'll say, you know, I don't understand what any of that means.
yes, you'll have to call them and say, hey, I don't understand your codes, and
Okay.
ask them to email them to you. So
Okay.
I have to do that every now and then too. And again, every county is a little different in what they call things. But yeah, there's a master list somewhere with you know, that shows what a property has to be to qualify as LA or to qualify as, you know, PDF or whatever. Yeah, but you have to ask for it.
Okay, perfect. Thank you.
Mhm. Anybody else?
I have a question for property in Harris County. When you file online, one of the questions for reason for protest is asking if you sold your house or bought it within the last 2 years. Are they allowed to ask that information?
No.
I didn't think so.
I
mean, I know they can find it because
they can find it. And the other thing, and this aggravates me, and I'm sure some of you have been in the same situation. Most of the time when you buy or sell a property, you'll get a letter from the appraisal district that says, oh, we see you bought so-and-so house. Tell us about your sale. Don't do that. They can ask, but you don't have to answer them. And so I've got one client this year that I'm going to have a tough time arguing that he's been treated unfairly because of something he said on that statement that he never had to say. Of course, they don't tell you that. So no, they can go look if they want to, but you don't have to supply that information.
Okay, good. Thank you.
I have a question. How is rental property valued? Is it just the improvement in the land, or does the rent affect the value?
No, it is a market value.
Just a market.
So, right. What would it sell for? So what you pay for it. Now, if it's a commercial property, they can do that on an income basis, but a home rental, a rental house, no, it's market value.
Thank you.
Question about a vacant lot, like in a new construction area. If the land value is significantly lower without an improvement versus the adjacent lot that has the house built on it, is that pretty typical that the land value is significantly different, meaning the developer gets the benefit?
No, and that's a great argument to make. There's a subdivision in Midland, Texas, where we've made that argument. The developers generally have, here I go sounding very cynical again, have buddies at the appraisal district. And so their lots tend to stay at a very low value until someone buys them, puts a house on them, and then the land values get jacked up. So yeah, I'd go in there and say, hey, every other piece of land in here is, you know, valued at $3,000 and you've got mine at 30. And I understand there's a house on it, but you've got me valued, the house is valued separately. There is no justification for the land value being higher just because it has a house on it than because it doesn't. So yeah, that's a great argument.
Paying less has a lake view.
Yeah, there you go.
Right. Thank you.
Anybody else?
I have a question.
Go ahead.
I know we're supposed to review and kind of critique the evidence that the appraisal district provides, but they always ask us, the protester, to provide evidence, pictures and estimates, receipts, that kind of thing. Are we supposed to be doing that?
If it is in your favor, absolutely. If it's not, you know, they don't have a right to get it. You have a right to get their evidence. They don't have a right to get yours. Now, when you go before the ARB, if you've got pictures or you've got appraisals or you've got things that help you, absolutely submit them. And they're going to ask you for anything you intend to submit. But just to ask you for anything generally, they don't have that right.
Thank you.
I have this is Lauren, I'm from El Paso. I have a question following up on that. So if we submit pictures in our favor this year showing cracks in the house or other faults on the property, can they hold that against us in the following year saying, oh, look, you painted the house now, or you cemented the cracks that, we took into consideration the previous year. Can they hold that against you the following years?
Theoretically, yes. Something that small, I mean, you've always got to be careful what you send them because you don't want it to come back to haunt you. But as a practical matter, what would likely happen is you get your reduction this year, and then next year, when they raise your market value, you might argue about something else. Then connecting the dots on deferred maintenance like that, they don't have the time to invest in that kind of detail. So it's a risk, but it's not a very big risk.
Okay, thank you.
But you brought up a really good point too. The deferred maintenance is probably the best just overall category of complaint to make. My house needs a new roof. Yeah, we painted the outside, but the foundation needs $20,000 worth of work. If you've got that kind of evidence, show up with it because it will make a difference.
Okay, thank you.
Do you have any suggestions for finding comparables?
Yes. If you're in a subdivision, that helps a lot. You can pull up the map like we saw on the statement I pulled up and just click on some of the neighboring properties and kind of see how they're valued. I've got a realtor friend and I call her and say, hey, have you got anything that will help me on this property? Realtors tend to like that because they figure then when you need one, you'll remember them. So I definitely ask that question. And then just get on the realtor.com website if we're talking homes and look around a little bit.
Okay, thank you.
I got time for one more.
Hi, I have a question. This is Teresa Wynn from around DFW. Have you seen a difference between the formal protest hearing with the full panel versus an informal kind of walk up and talk to the guy at the desk? In
terms of success?
Right, in terms of success, getting the property values reduced.
Definitely. I mean, as I was saying, most of the time when you go to a hearing, they're going to pull you aside and make you an informal offer. But sometimes that can happen well before a hearing. I mean, like I said, every county does it a little bit differently. If you can get a hold of an appraiser, and you want an appraiser, you don't want the receptionist, you want an appraiser, and talk through it with them, particularly if you can do it with some evidence in mind, or I've got one this year. It's a rental house. We bought it last year for half of what they got it set at. I mean, that is the definition of market value: willing buyer, willing seller. So those kinds of things can be argued pretty successfully informally. Formally, you sort of have to make that call. Is the argument you've got big enough, worth enough money, strong enough that you're going to risk the ARB just throwing you out because that's what they tend to do, and push you to an appeal? Or are you better off getting some relief now and not taking that risk? And that's going to depend on what size gap you're trying to close, or how far off is it, what are they offering, and again, what kind of arguments do you have? So it's just a judgment call.
Thank you.
Okay, well, they're fixing to kick us off, so I appreciate very much the participation and good luck.
Thank you.
Thank you.
Thank you. Thank you.